agents, brokers, dealers, trustees, transfer agents, assigns, assignees, employees, successors, and legal department et al. I, Derek Gonzalez, present this notice as the attorney in fact for and on behalf of Derek Gonzalez Estate and Trust, probated June 27, 1984, as evidenced by the State of Arizona State Registered Chief Probate Officer Grace Sadie DeLise Manning, and affirmed by way of public record, warehoused and archived in the State of Arizona Department of Health Services Vital Records Certificate Stock Number XXX XXXXX2612, a joint account number XXXXX0915, recognized and validated by and through the International Monetary Fund (IMF) Financial Crimes Enforcement Network (FinCEN) F X. Receipt number FX19000356001, BSA identifier 31000141265 Notice: I, Derek Gonzalez, am with the authority and duty bound to make an observation, create a record, and report said record to my principals. As such, I am a federally protected witness. Any and all correspondence sent to I, Derek Gonzalez, by any and all respondents must include one's full legal name, capacity, and title of the company one is gainfully employed with, a complete address including state, zip code, city, suite if applicable, a valid email address, a valid phone number with extension if necessary, and a valid fax number if one is available. All correspondence pertaining to the following subject matter must be signed with a wedding signature, or the response will be deemed to be a non-response. By complying with the following prerequisites, all respondents are duty bound to know by affixing your wedding signature to any and all correspondence pertaining to the following subject matter, one does so as a free will act and deed under their own unlimited personal, professional, civil, and criminal liability. Actual cash value. Actual cash value means, sorry about that. Let me do this for you. Actual cash value means the cash price you can sell an item for in the ordinary course of business without being forced to sell it. When you apply for a $100,000 bank loan, you sign a $100,000 promissory note. The note funds the $100,000 bank loan check back to you. What is the actual cash value of the promissory note? It is $100,000 because the bank sells it at the end of the day for $100,000 in government bonds, which has value equal to cash. What is the actual cash value of the new bank loan check? It is $100,000 because you can receive $100,000 cash. They merely exchange actual cash value for actual cash value and charge you as if there was a loan. Some of you may want proof. Federal Reserve Bank of San Francisco publication Monetary Policy in the United States, page 13, states that bank loans is funded by the banks creating new deposits. They claim there was a loan. The truth is, it was an exchange, and they called the exchange a loan. The proof is in the bookkeeping entries. No actual cash value was loaned as consideration to obtain the promissory note, and the proof is that the note funded the check. The proof that the note funded the check is the new money, the new deposit, as the Fed publication so clearly admits. It can also be tracked down with the MyNet Daily Log Transaction Report 120, showing the source of the funds and the destination of the funds. If you gave the bank $100 cash as collateral for a bank loan, and the bank loaned you nothing but deposited the $100 cash and used it to fund a bank loan check, refusing to return the $100 collateral, would you be mad? That is exactly what the bank did to you. When you hand the promissory note to the bank, it is equivalent. It has equal value to the bank loan check. After the loan is repaid, the promissory note has no value because the loan payment stopped. When they return the note, it has no value, which is the same as refusing to return the $100 cash collateral. If we followed the Constitution and only use gold and silver as lawful money, never use your promissory note to fund the bank loan check. The bank would be forced to use other depositors' money to fund the check, giving you equal protection under the law. This is why the bankers hate the Constitution, gold and silver money, and equal protection. Next time the media claims a group of anti-government, I bet that group believes in the Constitution and and in gold and silver, you are receiving the training of a bank expert witness. Volume 2 will significantly increase your skills. Volume 1 is the basics to get everyone up to the same level. Volume 2 is the banker's nightmare. The banks now know they cannot answer the following questions without exposing everything. Ask the banker to give his personal opinion on the following questions. If the bank demands I place $10,000 cash as a security with the bank to receive $10,000 loan, and the bank deposits the $10,000 into account, did the bank loan anything so far? The answer to that question is no. If the bank deposits the $10,000 to issue a $10,000 check from the deposit and returns the $10,000 check to me, did the bank loan me anything? The answer again to that question is no. Did the promissory note or lien act security for the alleged loan? The answer to that question is yes. If I deposit $10,000 cash into a checking account, does the checking account balance increase by $10,000? The answer to that question is yes. Does the $10,000 cash deposited and the new checking account balance of $10,000 mean there is now $20,000 of money that can be spent? The answer to that is no. The $10,000 cash in exchange for new money called checkbook money, you may spend the checkbook money by using a check, or you may exchange the checkbook money back into cash. We ask the question to prevent the bank from claiming they can create checkbook money without first depositing an asset money having equal value to the new checkbook money created. Checkbook money has equal value to legal tender, cash, just like a promissory note has equal value to cash because you can sell it for cash. Depositing cash, a check, or a promissory note, lien, security merely means that one exchanged the value of the funds deposited for equal value of checkbook money, and an exchange of equal value is not a loan. Mr. Banker, please answer the following questions. If one deposits $10,000 promissory note lien, does the checking account balance increase by $10,000? Yes. Does the new $10,000 checking account balance act like new $10,000 of currency one can spend? The answer to the question is yes. If the bank deposits a $10,000 promissory note, does the bank receive the promissory note for free and create $10,000 of new money in the same transaction? The answer is yes. Does this have an economic effect similar to stealing the $10,000 promissory note or future wages and counterfeiting rolled into one transaction? Yes. What right does the bank have to take $10,000 of actual cash value from a customer, consumer, natural person, depositor, original creditor, original source value issuer of all issue, deposit it and withdraw the money, and the bank keep the $10,000 as the bank's property without the customer's knowledge, authorizing, or permission? No. The book will prove this is the situation using the Federal Reserve Bank publication. Do you see why the bankers and government leaders fear this book? If this book got to enough American hands, the leaders would be forced to follow the Constitution, and great American presidents setting all Americans free of bank loans. The average American wife would have the option to stop working, stay home, and have the same standard of living produced and wife working today. If you keep giving future wages to the banker for free and they return it back as a loan, both spouses must work to support the banking welfare. Intent of agency. One of the requirements to become a certified public accountant is to take a business law course. The course I took in college taught that a loan contract has the following essential elements: an agreement with mutual understanding, competent parties, based on the approval, willingness on both parties, supported by consideration, money. The lender has to give up money to the borrower. 5, made for lawful purposes. 6, in legal form. An agreement must have full disclosure of material facts. Do I loan you money, or do you give me your money for free and I return it back to you as a loan? It is material who provided the money loaned. And again, the Money Daily Log Transaction Report 120 shows the source of the funds and the destination of the funds, which would be you. The course taught that an offer expresses the intent and willingness of the one making the offer to do or not do certain things. The three requirements of an offer are: one, contractual intention, the state of mind as to where the money is coming from to make the loan, and two, definiteness, knowing positively for certain, sure. Three, communication of the offer to the other party. If an offer is vague or indefinite, otherwise falling underneath the doctrine of vague and ambiguous, or is if essential provisions are lacking, there is no offer or acceptance or agreement. For an agreement to be valid, there must be a mutual understanding. Independent certified public accountants audit banks, accounting like police to protect the public. The CPA must follow audit guidelines and ethics. These guidelines require the CPA to know the intent of the borrower's agreement and be sure that the agreement and economic effect of the bank bookkeeping entries are in agreement. As judge and jury, you must decide if the agreement stated loan or implied loan by the words in interest, borrower, and lender, and whether the bookkeeping entries show an exchange but charge you as if there was a loan, significantly changing the cost and the risk. The CPA must have the competence to know the difference and must have investigated this requirement in the audit investigation. As the judge and jury, you must make a decision on whether there is a valid agreement or whether there was an intentional breach. The facts are simple. The bank advertised and wrote an agreement implying that money, credit, or a check to the borrower if he signed an agreement, a promissory note to repay the loan. The judge and jury will now consider the intent of both parties on a typical $10,000 bank loan. In simply as whether the bank led the alleged borrower to believe the bank would loan a bank check, cash equivalent, if the borrower agreed to sign the promissory note to repay the loan. Most borrowers I talked to believe the reason they signed the promissory note was simply to agree to repay the check loaned to them. That was the intent of signing it. Only the alleged borrower signed the agreement, so only the alleged borrower's signature is relevant to the intent. The bank had a far different intent in writing the agreement. The bank intended to receive actual cash value of $10,000 for free from the alleged borrower and return the $10,000 back to the borrower as a loan. The law allows the bank to create new tokens, checkbook money called bank liabilities, deposits, and IOUs, to match cash or government bonds. The bank simply used the promissory note to obtain government bonds for free and used the government bonds to create $10,000 new tokens, new money, as if someone deposited cash. The money supply increased by the amount of the promissory note. The bank exchanged the promissory note having actual cash value of $10,000 for bank tokens, checkbook money, having actual cash value of $10,000. The bank received $10,000 for free from the alleged borrower and returned it back to the alleged borrower as a loan. The bank required the alleged borrower to repay the alleged loan in cash or tokens. If the alleged borrower knew the bank loaned nothing of value for the promissory note, they would use their vote to change the system. When we took an opinion poll of the American people and told them the whole truth, they agreed they never had the intent of giving the bank $10,000 actual cash value for free and have it returned back to them as a loan. They had no idea. So they could not have had intent to fund the bank loan check. The borrower believed the tokens loaned were financed by other depositors. The alleged borrowers had no idea they financed their own loan and had to pay back the principal and interest to a third party who never loaned any actual cash value. The bank knew the truth and what their intent was. The bank wrote the agreement. They advertised and had the intent proven by the bookkeeping entries. They claimed there was a loan when, in fact, the economics prove that no loan existed, that there was an exchange and a charge as if there was a loan. I believe shows that the bank intended to make false statements, false representations to conceal the exchange in the agreement with the intent to reinforce a false impression, and failed to correct a false impression by showing the true intent and nature in the written agreement and banking advertising as to the transaction. Why did the bank change and conceal the true intent? It obviously than the risk of the alleged loan. The change allows the bank to obtain the asset of the nation for free and to force us to pay them interest on what they received from us for free. If the banker's intent was not concealed, informed Americans would be outraged and vote out everyone aiding and abetting the bankers. Can we prove the intent of the borrower? Sure, we can. What borrower do you know that is stupid enough to agree to give the bank a gift of $10,000 of actual cash value and have the bank immediately return it back to the same person as a loan? Americans are not that stupid. They have to be tricked into it. Can we prove the intent of the bank? Yes, by the bookkeeping entries, the stamp on the back of the promissory note as will be discussed later, and bank policy. So they're using false and misleading, deceptive trade practices in order to unjustly enrich themselves, causing RICO violations to occur rampant because they're being paid to do so. They created the policy, and because they created the policy in the contract, he who bears the benefit also bears the burden and the liability if the contract is deemed to be invalid. Bank auditor from Texas. True story. A radio station in Texas invited me to speak about bank loans. After I spoke, a man called identifying himself as a former CPA bank auditor. He told me he always knew that something was wrong, but could never quite put his finger on it. In a matter of minutes, I explained how I felt. The bank auditor was concerned that he could go to jail. I said we do some role playing as if we were in court. I told him to pretend he was on the witness stand. I said, do you have the competence to conduct a bank audit? He said yes. He admitted that under the CPA ethics, he had no choice but to say yes. I asked, did you determine if the bank legally owned the promissory note? He said yes, that this is part of the audit requirement. I asked him on a $100,000 bank loan, how much legal tender must the bank loan for the bank to legally own the $100,000 promissory note? He responded that it would have to loan $100,000. I knew he had just made a fatal mistake. I asked, what does $100,000 bank liability mean? He said it means the bank owes $100,000 of legal tender. I asked him if a check is money or merely an order to pay money. He gave the standard reply, stating a check is the same as money because you can redeem it in cash. I asked him if, according to the Uniform Commercial Code, it is money or merely an order to pay money. He said, don't worry about it. I said, do you have the competence to answer the question? I knew he could not say no if he took on a CPA bank audit assignment. He finally confessed that it is not money. It is merely an order to pay money. I asked, according to the standard bank bookkeeping entries and according to the Federal Reserve Bank policy and procedures, who provided the original capital to fund the bank loan check? Was it the bank or the borrower? He said, if I answer that question, I might go to jail. He admitted the check and liability is not money. He admitted that the bank must loan $100,000 of legal tender to the borrower in order for the bank to legally own the promissory note. That means the promissory note cannot fund the bank loan check. He became very upset and concerned. He explained that if the bank does not legally own the promissory note, then the audit was incorrect and must be changed. If this were done, it would open the door to a lawsuit. He very, very well might go to jail. The next day, he called me, claiming he'd found a weakness in my argument and charging that the banking procedure was not check kiting. I asked him if the word loan meant money advanced to a borrower to be repaid at a later date, usually with interest. He said yes. He had no choice. He had to say yes. This definition of the dictionary. I asked him if the bank records legal tender as he said yes. This refuted his claim that the local bank have a license to create the opposite of legal tender bank liability called checkbook money, owing legal tender, and loan the opposite of legal tender to the borrower. I asked him if it is a standard policy for the bank to record promissory notes as a loan from the borrower to the bank. Obviously, the answer is yes. He knew I had the Federal Reserve Bank publication showing the standard bank bookkeeping entries, which recorded the promissory note as a bank asset offset by a new bank liability. This is economically the same as loaning the promissory note to the bank and the bank loaning the value back to you. He knew that if it is material to disclose a loan from the bank to you, it is equally material to disclose a loan from you to the bank. If it was not a loan, it had to be a theft. He could not answer the question. I asked him, according to your understanding, is the promissory note money or not? He told me he could not answer this question in court without going to jail. Later in the book, I will explain why he gave this response. More and more professionals joining to save America. A true story. Jeff, a Californian CPA, asked me to train him as an expert witness. I had him listen to my 15 hours of cassette tapes and read my manual. I then flew to Los Angeles and met him at a friend's house. I spent hours writing on a chalkboard explaining the bank loan agreement. The best way to teach him the concepts was to hold a mock trial. I asked Jeff to pretend he was the bank president or CPA expert witness on the witness stand. As an expert witness, you must know everything about banking. You cannot claim you do not know an answer to a question in the area you are testifying in. I asked Jeff, do you know the Federal Reserve Bank policies and procedures regarding loans, deposits, and bookkeeping entries? He said he did. Is the bank liability a banker's debt? I asked. He said yes. Do banks charge interest for the use of borrowed money? Yes, they do, he said. Is this a $100,000 promissory note? I said, hypothetically, hold up a piece of paper. He said yes. If the bank refused to loan the borrower a $100,000 check as consideration for promissory note, do you believe the bank would legally own the promissory note? He said, if the bank refused to loan the money, the bank would not legally own the promissory note. Does a bank liability mean the bank owes legal tender? He responded, yes. Is the check money or merely an order to pay money? He responded, it is not money. The Uniform Commercial Code says it is not money. It acts like money with the assumption that there is to make the check valid. Is it your assumption the bank followed the Federal Reserve Bank policies and procedures? He said, if they didn't, they would go to jail. Is it your opinion that the bank legally owns the promissory note? He said yes. I said, Jeff, if this were a real court case, I think you would be headed to jail. At the very least, you would have the case. He asked me what the problem was. I explained that the check could never be the consideration loan for the promissory note. If the check was then there was no cash or asset behind the check, making the check illegal. The Fed publications state that the bank never loans other depositors money or legal tender as consideration for the promissory note, according to the federal publication. The promissory note is used as the value to fund the check. If the promissory note funded the check, then the check could never be the consideration loan because the bank owned the promissory note without loaning 1 cent of legal tender. Which came first, the chicken or the egg? The question is, did the bank steal the promissory note or record it as a loan from the borrower to fund the check? Did they lie and claim the check was the consideration loan to obtain the promissory note? Key lesson. Most non-bankers believe the bank bookkeeping entries were the opposite of what the agreement actually was. There is no agreement without mutual understanding. Did the agreement imply a loan of the bank's money to the borrower or a loan of the borrower's money to the borrower? The bank does not want to answer which came first, the chicken or the egg. Ask me, what if the bank sold the promissory note? Was the promissory note stolen? Look up the words receipt of stolen goods and property, and I think you'll agree that the one who bought the promissory note understood the bank policy, standard bookkeeping entries, and agreement. They had knowledge and intent. Buying a car was stolen makes you guilty. As judge and jury, you must decide if the question of the promissory note is receipt of stolen goods or property. Stealing is defined as obtaining another's property through a trick, a dishonest act without authorization or permission given, larceny, embezzlement, false pretense, or other wrongful acquisitions. Larceny is defined as obtaining property by unauthorized means through fraud, false representation, intentional perversion of the truth, deception with intent, or perceived plan to convert or steal. Larceny by fraud or deception is defined as obtaining property by deception, using or creating a false impression and or reinforcing a false impression, or preventing one from obtaining the correct information that may alter transaction. The deceivers failed to correct the misleading information which he previously created. Example: the bank claimed there was a loan when there was only an exchange of equal value, and then they charged you as if they loaned you their money. The deception changed the cost and the risk of the transaction. Through this trick, the bank could obtain nearly all the in the nation for free. Judges and attorneys have routinely refused evidence into court. Larceny by fraud, extortion, and concealment are committed when a court prevents one from bringing evidence into a court for one's defense. The lawyer reinforces a false statement claiming there was a loan, concealing that the bank took actual cash value from us, returned it back to us, and claimed it was a loan from the bank and not a return of the unauthorized loan from us to the bank. Please look up the words conspiracy and white-collar crimes as well. The bank told you that you received a check you can cash for legal tender, and that the check was the loan allowing you to buy the house, the car, the boat, the plane, etc. All one has to do is follow the money entries to see that this is not the case. How does society value money? Money is only worth the products it can buy. Money is valued by the labor required to obtain it. Your employer gives you a paycheck because you sold your labor to him in exchange for money. Before money existed, people bartered their time for other people's time. Joe agreed to work 5 hours to fix Randy's wagon, and in exchange, Randy agrees to work 5 hours to fix Joe's plumbing. Money merely made it easier to barter one's labor. It is the medium of exchange for other people's labor. Money can be valued in time, and banks charge interest for the time money is borrowed. When you buy food, you barter your time for the farmer's labor. A gold coin has value in itself. You could melt the coin down, and people will still trade their labor for the melted gold. If everyone money and stopped working, people would have houses full of cash and no food, water, electricity, or gas to fill their cars. Bankers know labor is more valuable than counterfeit money. Labor produces wealth. A counterfeiter receives your labor for free and devalues the money and savings by the inflation caused by the counterfeiting money. If your neighbor loaned you $10,000, he worked 1,000 hours to earn the money, you will work 1,000 hours to repay the loan plus interest. Money was the barter mechanism to exchange labor for labor, value for value. No one stole anything from anyone. If banks loaned other depositors money, you would receive a loan of their labor to be repaid with your labor. No one stole or counterfeited. No one received another person's labor for free. But the bank never loaned you value for value. They did not loan you 1,000 hours of labor to be repaid by 1,000 hours of labor plus interest. The bank received $1,000 future hours of labor for free, and this labor gave value to the new money that the bank created and claimed it loaned to you. Your labor funded the bank loan check. The bank received your labor for free when you paid the principal and interest. Then, often, the bank forecloses and receives the property for free. The borrower is constantly giving the bank his labor without receiving any of the bank's labor or other depositors' labor in return. The banks claim Congress gave them the right to create money and receive Americans' labor for free. A thief and counterfeiter can receive your labor for free too, unless they are caught and go to prison. If you are constantly stolen from or forced to give your labor to another for free, you will be poor, in debt, and bankrupt, while the one receiving your property for free gets working. The cost of the bank created money is the cost of having today's value of your future payroll checks stolen and used to create new counterfeit money value that is loaned back to you at interest. It is not only the cost of stealing and giving you back a debt in place of the property future payroll checks stolen, it is also the cost of inflation and devaluation of currency created by the counterfeit money. The cost of Lincoln's money eliminates the cost of stealing and paying new interest on new debt. Lincoln needed $449,338,902 in taxes, borrowed funds, or newly printed greenbacks to finance the war. The bankers wanted Lincoln to print the money and give the cash to them free, or to have them create the money and loan the cash back to Lincoln at 24% interest to 36% interest. That would cost the taxpayer $449,338,902 plus $161,762,000 in interest every year. The great grandchildren of the taxpayer would be paying the great grandchildren of the bankers this interest today if Lincoln did not refuse to give the cash to the bankers for free and return it as a loan to the government. Lincoln printed $100 for less than 1 cent, making a profit of $99.99 for each $100 printed. The new money was used to pay the soldiers and bought the guns, saving taxpayers the money. Lincoln's solution saved the taxpayers $449,338,902 plus interest. The controversy is over who receives the $449,338,902 for free, the taxpayer, government, or the bankers. The government is supposed to belong to the voters. It was never intended to be taken from the voters and given to the bankers. The cost and the value of money is much more than labor, interest, and debt. It has to do with who controls the government, the value or an economic slave or free. As our founding fathers intended, do the citizens own the country and government, or do the banks? If you are forced to give your labor away for free, over time you will be broke and will lose your country. United States notes are the banker's nightmare and the citizen's salvation. Real Americans who love our government and Constitution and know we fought the Revolutionary War to stop banks from creating money and only allow the government that privilege will conclude that President Abraham Lincoln was right and that the United States notes have the greatest value to society. When we return, we'll be hitting up number 12. What is money in America?